Morning, afternoon. We journalists have always needed people like Gunita Singh to help pry open the doors that so many people in power are determined to lock. But frankly, we need them more now than ever because there are so fewer of us to fight the fight. I strongly believe one of the most important things newspapers did historically was fight for open government. And the loss of local papers and the smaller staffs at the papers that survive have left a dangerous void. Close to home, very close to where we sit, 25 years ago, YSU's trustees hired a new president behind closed doors. And what was the reaction? Using open meetings laws that had not yet been gutted, the press attacked the appointment on legal grounds, and the faculty, student body, and the public rallied around, and the board had to give in to pressure and rescinded that offer. More recently, when the Board of Trustees did the same thing, arguably even more egregiously, the board simply ignored the requests for explanations. Exceptions had been chiseled into the Sunshine Law that allowed them to stonewall until their problem evaporated. 25 years ago, the Vindicator had 3 editorial writers, all hammering the trustees relentlessly. By the time the Vindicator closed, there was 1 full-time editorial writer. And I'm not sure how many the Trib Vindicator has now, but it isn't 3. Likewise, the staffs themselves are much smaller than the one I joined at the Vindicator in 1971. They're working hard, there just aren't enough of them. The Mahoney Valley is not an exception. There are areas that have fared even worse. Now, that's why we need the Reporters Committee for Freedom of the Press, a nonprofit, and people like Gunita Singh to fight the fight for us. As a graduate of Georgetown Law, who also passed the notoriously difficult California bar, she no doubt had other options available. But she chose to be on our side here. She chose to be a staff attorney for the Reporters Committee for Freedom of the Press, where she works on litigation, policy, and amicus briefs, primarily around state and federal freedom of information laws. She also helps reporters and news organizations with records requests. She has co-authored 2 publications about the effect of COVID-19 pandemic on the access to public records. The First Amendment hasn't changed, but how it is honored has. Issues that were only the subject of nightmares during my career are the stuff of her days, and I look forward to hearing from her and ask you to welcome Gunita Singh.
I was not expecting such a lovely and warm introduction. Thank you so much. That really has been just the highlight of my week. Thank you for that. I'm so delighted to be here. This is my first time in Ohio, and there was a Supreme Court case I read in Youngstown, in law school, about the Youngstown Sheet and Tube Company. So to be here and just to soak in all the history has been really lovely. So thank you all for that warm welcome. And I assume everyone can hear me okay, but please just holler if I drift too far or something. And I'm gonna set my timer so I don't go overboard for 30 minutes. Leave enough time for Q&A. I'm so excited to learn from you as well as to hear any questions you may have. But yes, without further ado, I will go ahead and get started. As Dennis mentioned, I'm from the Reporters Committee for Freedom of the Press, and if any of you are unfamiliar with my organization, we've been around for over 50 years. So we were founded in the year 1970 at a time when journalists were being hit with an unprecedented wave of government subpoenas to reveal their confidential sources. And since then, we really pride ourselves on having become a one-stop shop for virtually any legal need that a journalist may have. And something that I'm really proud of is we take a broad definition of news media. So whether you're at an established outlet or you're a freelancer or a blogger, maybe YouTube is your preferred method of dissemination, or you're a documentary filmmaker, so long as you're in the business of, acquiring information, analyzing it, contextualizing it, disseminating it, our services are for you. And we don't charge a penny for any of the services that we offer. We provide all of our legal services pro bono. bono. So I couldn't be more proud to have worked at the Reporters Committee for coming on 6 years now. And I wanted to flag that as part of our local legal initiative program, the LLI program, we have attorneys on the ground in the 5 states that you can see up there. And so while we don't have anyone in Ohio yet, I still wanted to flag that if any of your reporting implicates one of these jurisdictions, maybe there's a court proceeding that you're following in Pittsburgh and the docket items on the court docket are sealed. You could call one of our attorneys and we'll help you to file a motion to intervene in that case for the purpose of unsealing those court records. Maybe you are trying to get public records from an institution in Oklahoma and they have ghosted you, as the youngins like to say, or they have improperly redacted or withheld information. You could call one of our attorneys to help you with that, and so on and so forth. But we are in the process of expanding, so stay tuned. Maybe one of these days we'll have someone on the ground here. So I wanted to take a second to zoom out. So my area of focus is freedom of information. So I'm suing federal agencies, I'm suing state agencies when they wrongfully delay or deny you access to public records. But in the field of media law, even though it is a very niche field, it encompasses a lot of different practice areas. So at the Reporters Committee, we do defamation defense, we do subpoena defense, and we do access to the courts and access to public records. But I wanted to zoom out and talk about the two main authorities that we work with to secure a healthy landscape for journalists like yourselves. And the first is, of course, the First Amendment to the Constitution, but you've also got the Freedom of Information Act passed in 1966 by Congress. And I feel like the 2 Supreme Court cases that I put here, even though on the one hand, the Supreme Court is interpreting the First Amendment, and on the other, it's interpreting a statute, the Freedom of Information Act, I feel like these 2 quotes dovetail so beautifully together and really paint a picture of why I love what I do so much. So in the first case, First National Bank versus Bellotti from the 1970s, the Supreme Court is saying that the First Amendment scope encompasses a range of conduct related to the gathering and dissemination of information and prohibits the government from limiting the stock of information from which members of the public may draw. And I think that's really beautiful because all of us here are obviously familiar with the First Amendment, but in this quote, the Supreme Court is saying that the Constitution doesn't only protect freedom of speech, it also carries in it some freedom to listen. So I find that to be really inspiring. And I think that dovetails really nicely with the Supreme Court's interpretation of FOIA, the Freedom of Information Act, and the statute that I work so intimately with, because in that second quote, you can see the Supreme Court saying that FOIA it shouldn't be dismissed as a convenient formalism. It is a structural necessity in a real democracy. And I think that is something that all of us here can resonate with, right? The fact that a free press and a healthy landscape for journalists is essential and actually a prerequisite for a robust democracy. So after having set the stage, I thought I would dive in and just talk about a handful of examples of work that we've done at the Reporters Committee. And some of them I would define as war stories, and some of them I would define as like real victories that hopefully leave some of you feeling inspired by the time we finish this talk. So one of our clients is a film production company called Codebreaker Films, and they produced an incredible documentary called Reality Winner. And if you haven't seen it yet, I'm pretty sure it's streaming on Amazon Prime and some of the other major streaming platforms. But they were focusing on Reality Winner, who, if you don't know, she's a whistleblower who, when she was so young, in her early 20s, she was contracting for the federal government. And during the course of her work, she came across what she interpreted as conclusive proof of Russian interference in the 2016 election. And whatever your thoughts are on what is the proper response, being in a situation like that, she viewed it as her civic duty to get that document out in the open to inform public debate. And the FBI eventually found out that she was the individual who leaked that document to the press. And they went to her home and they interrogated her. And so the FBI has the audio footage of that interrogation between the agency's agents and Ms. Winter. And my client, Codebreaker Films, wanted access to that audio footage to incorporate it into their documentary film. And I just thought that having seen the iteration of the film without the audio footage and seeing it with the audio footage, hearing the fear in her voice, what is it like for a 23 or 24-year-old girl to be interacting with agents of the federal government? I mean, it brings up in you a wide spectrum of emotions, right? There's the intellectual aspect of, okay, she did this, she broke the law. There's the emotional aspect of, here's a kid who wanted to do something that she thought would help inform public debate in this country that she served as a member of the U.S. Armed Forces. She's a veteran. So we sued the FBI, my colleague and I at the Reporters Committee, and this quote that you see is an excerpt from the transcript of one of the proceedings held in U.S. District Court in the District of Columbia. And I really love this quote because the judge in the district court for DC, she said it was ridiculous that the FBI was delaying access to these audio recordings. And I really enjoyed that she chose to use that term, because when you do FOIA litigation, a lot of times, there's a lot of deference to these federal agencies when they say, oh, we've got these backlogs, and these exorbitant backlogs exist because we're short-staffed. And of course, as a human being, I have sympathy for that. I mean, we've all been in a situation where we felt like we could use extra hands to get the job done. But the thing is, the Freedom of Information Act is a federal law, and under FOIA, the agency has 20 business days to provide you with a determination about what they intend to withhold and what they intend to produce. And here, look, you can see the request was pending for 2 years. And so the judge went on to say, the plaintiff, so my client, Codebreaker Films, they acted in good faith in narrowing the scope of their FOIA request to just this 2-hour-long interrogation audio clip. The FBI could get this done in a day if it really wanted to. So I really appreciated that the court, did its job in terms of striking that balance between giving the agency a couple extra weeks to get the job done, but still prioritizing the right to know that the public and the press are guaranteed by this statute duly enacted by Congress. And that 2 weeks that the judge gave the agency to get it done was exceptional, because that meant our client was able to secure the audio footage, edit the film, incorporate it into the film in time for its worldwide premiere at South by Southwest. So definitely check out the documentary if you haven't yet. This is probably one of my favorite FOIA war stories. So my colleagues and I at the Reporters Committee, we've got some ongoing litigation, again, against the FBI, and the backstory here is really interesting. So some of you probably remember that about 10 years ago, actually exactly 10 years ago, the Cliven Bundy family in Nevada, a bunch of cattle ranchers who were protesting the imposition of grazing fees by the Bureau of Land Management in order for them to graze their cattle on public lands. Well, the Bundy family didn't take kindly to the government imposing grazing fees, and the government was actually saying, you, the Bundy family, you owe us $1 million in back pay in terms of grazing fees. And so there was that armed standoff, some of you might recall, between the cattle ranchers in Nevada and the Bureau of Land Management, and also the FBI, I believe, was there. And that standoff did not go well. Basically, the federal government had to retreat. And the FBI wanted to do something about this. So what the FBI did was they had their agents impersonate members of the news media in order to go back to Nevada and to solicit incriminating statements from the Bundy family and their friends and supporters. And I don't know about you, I have a feeling that I know what this is evoking in you all as journalists and affiliates of journalists. But for an agent of the federal government to pretend to be an independent journalist is honestly terrifying to me. I mean, that is just not proper. I don't know how else to say it. As members of the news media, you all take pride in being fiercely independent. And so for the government to come in with their own agenda and to impersonate you guys, I mean, we were not having that at the Reporters Committee. So we filed a FOIA request with the FBI to learn, how often is this happening? What are the guardrails in place to ensure that a technique this extreme is not being used willy-nilly every single day. I mean, are there procedures to get this authorized by someone like the Attorney General? Like, what is going on here? We really wanted to learn more and then educate our stakeholders and constituents. And that FOIA litigation is still ongoing. It's been years and years and years. But we were able to get this particular image, which is an image from the fake website that the FBI made when they were in person. I love the face you're making. For reference, everyone, this is the face Lori's making. Because when I was in middle school learning HTML, I think I could have made a better website than this. I mean, this is so tacky, is it not? But yes, the FBI, they were touting this phony production company called Longbow Productions, and this is the website they made. I mean, look at these come on. Our taxpayer dollars at work, y'all. So when we filed the complaint against the FBI, because of course the FBI, they were delaying access, and so we went into federal court to try to get some judicial oversight over this. You know, we had questions that we needed answers to. In our briefing, we basically styled our briefing to say, okay, Judge, we know this is a FOIA case. We know that your oversight is limited to interpreting, is the FBI complying with its obligations under FOIA? But because you are a federal court, you are, of course, empowered to consider the First Amendment and the power that it holds when rendering your opinion. So what we did was we filed declarations. You know, these are statements that are made under penalty of perjury. And we filed declarations from actual documentary filmmakers, renowned documentary filmmakers, who said, knowing that this is happening, this threatens the integrity of my career. The fact that this is happening and people are starting to know about it, it actually puts my life in danger. Because when I'm trying to forge that sacrosanct reporter-source relationship, they don't trust me, despite all of the best practices that I learned in J school, despite all of the best practices that my own intuition is telling me to use as a journalist. This puts my life and my work in danger. Unfortunately, it didn't have the impact that we were hoping. This case, as I mentioned, is still ongoing, but stay tuned. Maybe if you have me back in another 10 years, there will be some good development I can share. But yes, never a dull moment in FOIA litigation. And this is perhaps one of my favorite stories to share. So as some of you or all of you may know, under federal FOIA, there are enumerated exemptions to disclosure, right? Maybe to protect somebody's privacy, or if a law enforcement investigation is ongoing and disclosure of the records could interfere with that investigation somehow. And of course, all of the 50 states plus DC also have their disclosure provisions under the Sunshine Law and the exemptions that accompany those. So under federal FOIA, maybe some of you have heard of the notorious deliberative process privilege. And this privilege is the most misapplied, overused exemption in federal FOIA. But I'll start with the rationale for why it exists. Basically, Congress thought when government personnel are in the process of formulating policy, we don't want them to feel like they're, quote, operating in a fishbowl, right? They should have the freedom to exchange, the widest array of ideas, and we don't want them to feel like they're half-baked, not fully fleshed out ideas are gonna be subject to disclosure because it could harm agency candor. That's the phrase that you see over and over in the case law. But the problem is that's a little bit subjective, right? Harming agency candor. And the problem, and Congress has recognized this, and that's why Congress has amended FOIA in recent years to try to make it harder for agencies to withhold information. The problem is the deliberative process privilege is so often used to just shield information that the agency might find embarrassing, or that would paint it in a negative light. So this is an actual example of a record released by the US Department of State to a FOIA requester. And the FOIA requester successfully administratively appealed, so they got the agency to take another pass at the propriety of its withholding. And the requester got the redaction lifted, and it said, "What a bunch of crap." Does that strike you as particularly deliberative? So obviously this was just a case where the State Department didn't want to admit that its personnel were being a little bit less than professional. So I guess the advice that I would give to you, if any of you are still doing FOIA requests, is always be vigilant, always be skeptical, but especially if the agency invokes the deliberative process privilege, right? So now I thought I would give some really inspiring stories that I'm really proud of. So a couple of Reporters Committee attorneys are actually instructors at the University of Virginia First Amendment Clinic. So those student lawyers, those lawyers in training are receiving guidance from some of the best media lawyers in the business. Obviously I'm biased, but I love and adore my colleagues, and they're doing such great work at the clinic. And the UVA clinic actually instituted some litigation against the Virginia Department of Corrections on behalf of a newsroom called The Insider and one of its journalists. And what The Insider was trying to do was to understand the really grotesque practice of using dogs to try to maintain order in Virginia prisons. And just weeks ago, the UVA clinic, under the guidance of Reporters Committee attorneys, was able to secure a tremendous victory in the trial court, where the state court said that the Department of Corrections was in violation of Virginia's FOIA and needed to release footage of what happens when these dogs engage with the inmates, bite them, attack them, maul them. And that the bite reports, the reports generated after these engagements, as they're called by the Department of Corrections, also needed to be produced. And I really wanted to highlight this in particular, because it's so recent, and it's a testament to what we've been able to accomplish, just recently. But I think that when we talk about sunlight and freedom of information, sometimes our brains go to this place where we mostly associate that with lofty concepts of democracy. And yes, that's so valid, because part of why these laws exist is to foster a robust democracy. But it's really about on-the-ground accountability, right? The notion that upon receiving these records, this footage and these bite reports, the notion that could inform change and make life better for some of our most vulnerable populations, that's really why I do this work. And I thought that I would end by talking about one of my favorite cases. All my clients are like my babies. I'm just fiercely protective over all of them, and I'm committed to zealously representing all of them. Azmat Khan holds a special place in my heart just because I'm so moved by the work that she's doing. She's really made it her life's work to understand the full scope and extent of civilian casualties that resulted from the war on terror. And she was a contributing writer to the New York Times when we took her on as a client, but now she's been hired full-time by the Times. And that's really just a testament to the integrity and the quality of her reporting. But what I love about Azmat is she's doing what I call a multi-tiered approach to her reporting. She's gone on the ground to places like Syria and Iraq and Afghanistan to talk to families that have been impacted by drone strikes. But she's also suing the Pentagon with the help of Reporters Committee attorneys like myself and my colleagues. And as a result of our FOIA litigation, she has been able to get thousands of pages of records from the Defense Department. And her hard work analyzing those, contextualizing those, and ultimately reporting on them got her a Pulitzer Prize 2 years ago. So I would highly encourage you to check out her work, the Civilian Casualty Files, if you haven't already. But if it weren't for her reporting, then we wouldn't understand that so often these airstrikes are predicated on inadequate surveillance and faulty intelligence. And if it weren't for her reporting, we wouldn't be able to bear witness to the fact that in 62% of airstrikes, children are injured or killed. That's not a figure that we had beforehand. The Pentagon, before her reporting, said that figure was 27%. But as a result of these primary source documents, this is why I love FOIA so much. There is, for better or for worse, a lot of debate these days. Can we trust the media? Let's analyze the bias. Everyone's got a bias. But the thing is, when you get primary source documents from the government itself, you let that do the work, So I was just so grateful to Azmat Khan for allowing us as Americans to bear witness and have all the facts and all the information. So this is kind of a snapshot about why I do what I do. It's a snapshot of the smattering of cases that the Reporters Committee engages in order to elevate the right to know of the public and the press. And I resonate that I understand that I've got 8 minutes left. I was supposed to talk for 30, but maybe I was talking a little bit fast because I was so jazzed. But, please keep in touch. The Reporters Committee has a hotline that is staffed 7 days a week by attorneys like myself. And it's really there for you to get an answer to virtually any question you may have about your news gathering rights, or what to do if you've been stonewalled by an agency, or maybe there is a court proceeding happening this afternoon and you want to know, can I get a camera in the courtroom? We are here to help you answer all of those questions and more. And it really is the sort of thing that we live and breathe and take so much pride in this work. So we'd be delighted to help you with any legal need that you may encounter. Thank you.
Question. Of all the different areas of law when you were in law school, how did you settle on this particular area of the law?
I love that question. The short answer is I grew up on punk rock. So I always had a little bit of an anti-establishment streak in me. So getting to sue the government is pretty fun. But the long answer is when I was in college at Boston University, I was really interested in the animal rights movement. So I was doing a lot of activism in my free time. And I met someone through that community who was doing his PhD at MIT, and his name is Ryan Shapiro. And if you look him up, you'll probably see the term FOIA terrorist online, because that's what the government affectionately calls him. But he really opened the door for me, because when he was doing his PhD in the history of government surveillance of animal rights activists, he was relying on the FOIA as his primary research tool. So I was 19 years old when this guy told me about FOIA, and I was just like, why do we not learn about this in civics? I mean, this is the most democratic law I think I've ever heard of in my life. I hope everyone knows about it. So really, since then, I was so drawn to the idea of using that law to facilitate accountability and transparency. And then as I got deeper into my career, I realized, okay, it doesn't always work in practice as it's supposed to on paper. So I got really motivated by the idea of trying to correct that imbalance and I guess bridge that asymmetry to create more sunlight.
I have a question for you too, if
Yeah.
you may. Do you know, are there any pending FOIA cases that might be before the Supreme Court? Is there anything like that that's gone that far?
Yeah. I mean, just recently, I think the most recent Supreme Court case that was a FOIA case was Justice Barrett's very first opinion, if I'm not mistaken. So this was maybe a year and a half ago, and it was a case that involved the Sierra Club suing the Fish and Wildlife Service. And it was a case that had to deal with the deliberative process privilege. And, it was a mixed bag, that case, but there was some really good language that came from it, because a lot of times what government agencies will say is if something is a draft, they sometimes view it as inherently deliberative just because it's not final. And they say, oh, this is grounds to withhold it because it's a draft. But the drafts can sometimes be really illuminating. Like, we want to understand what range of considerations did the government look at before they settled on the final thing. So to Justice Barrett's credit, she did say in that case that the nature of it being a draft is not necessarily dispositive. You need to dig a little bit deeper to figure out, is this really deliberative and subject to withholding? But that was the most recent one. Coming up, I don't know off the top of my head if anything is slated to be considered by the High Court.
Thank you, but my reason for asking is, given the ultra-conservative intent of several of the justices,
I know.
I'm wondering if there might be some diminishing or attempts to diminish, or I won't say rule unconstitutional yet, but
Yeah.
I could see people like Alito and Thomas trying to adjust destiny. Maybe
No, I understand the concern. I will say, the reason why I'm not staying up at night worrying about that in this particular moment in time is because some of you may already know this, but in 2016, Congress actually amended FOIA after a series of hearings, in particular about that wicked deliberative process privilege, and they determined that they wanted to provide an additional level of burden that the agency needed to satisfy in order to withhold records. So now the current state of the law is It's not enough if a record simply comes within the ambit of one of FOIA's discretionary exemptions. Now the agency has this heightened burden of demonstrating that reasonably foreseeable harm would, not could, would flow from disclosure of this record. And sometimes agencies are acting as if this change in the law didn't take place and they're not doing that extra calculus. So that is a problem, to your point. But we are starting to see agencies just now taking that extra burden seriously. And as a result, I think we have more access than we did, I'm really bad at math, 8 years ago? Almost 2016. We're starting to see more access than we did prior to those amendments. So I'm confident that the courts are gonna honor that amendment to FOIA, which was undergirded by wanting to facilitate more, not less transparency.
Thank you.
Sure.
There's two things in the journalism world that cause deep consternation in me, and I was wondering if you could maybe address both of them or in your view. One of them is, as you're probably aware, one of the individuals running for president is often referred to the press as the enemy of the people. And also, there's this sort of false narrative that anybody who posts something on social media can call it news, no matter its veracity or lack thereof, or truth value. And it seems to me that both of those dynamics greatly undergird and also damage the credibility of journalism in the public's eye. To what degree it's hard to determine, but it does do that level of damage. And I'm wondering what you think of that, and also do you think that that would have any deleterious effect on agencies willing to release information under FOIA?
Yeah, those are really good points that you bring up. On the first one, I'll say that I'm a big believer that FOIA matters regardless of who is in power. You're absolutely correct that some of the rhetoric used by former President Trump caused tangible harm. I mean, we saw violence at protests where members of the media were there to cover events really escalate against journalists, and that's terrifying. And so as part of our repertoire at the Reporters Committee, not only do we give trainings on best practices for things like, pre-publication vetting and Freedom of Information Act, but we also give trainings on how journalists can stay safe at protests, how to wear your press credentials and, have the number of a criminal defense attorney on hand, ways to lock your phone, etc. But I'll also say, under President Obama, more FOIA requests were denied on national security grounds than under President Bush, who came before. So there's always a need for vigilance. I feel very strongly about that. And then, on your second question, you're right. There are varying degrees of veracity when it comes to reporting. But under FOIA, for example, the individual's purported need for the records doesn't actually matter. So everyone is kind of considered equal under the eyes of the law. And I kind of think that's a good thing, because it doesn't matter whether you're a journalist or a citizen or a non-citizen, just a curious party. All of your rights under the law are sort of ceteris paribus. But yeah, I struggle with how to remain as digitally and news literate as possible in an age where misinformation is rampant. I think just personally, I don't know if the Reporters Committee has an institutional view on this, but we should be teaching digital literacy in schools. I mean, in an age where it's kind of, when I was in law school and we learned about the marketplace of ideas, right? John Stuart Mill, I would have this mental image of all these ideas in a boxing ring, and eventually the truth would prevail. That's really hard in an age of misinformation where we don't always know what's what, but that's part of why I rely on you all so much. Part of why I rely on you all so much, the integrity in this room and the dedicated approach to news that is thoughtful and honest and accurate is just so inspiring. And I love having people like you as my clients. I sometimes think that I could have taken a different approach, but I can always sleep good at night knowing that my clients are on the right side of history.
I'm going to guess that you weren't a member of the Federalist Society at Boston College. But as a lawyer, what's your view of a group like that, with billionaires backing it, taking a long haul view, almost that eventually they're going to be able to overturn decades, centuries of precedent on matters of public interest and others.
Yeah, it's tricky. I obviously support their right to associate, right? Part of why I got into this work was because I wanted to defend everybody's right to speak, even if I disagree with them. And I think that I've learned the most from some of those moments of what I call fruitful friction, where there's healthy debate and maybe everybody has something to learn. But gosh, it's a tricky question. I mean, part of why I love the Constitution so much, and like I really love the Constitution, I have parts of it tattooed on me. I mean, I love it so much, is I think that I think that the founders, they created a document that had enough structure to withstand the test of time, but they also embedded in it enough flexibility to allow for the ebbs and flows of a far from static society. And the Federalist Society is taking one interpretation of that document and how they want it to be, you know, embedded into the everyday life of Americans today. And there are groups with different views. I don't really know what else to say about that, because I deeply believe in their right to associate. And even if they inspire a love and an adoration for the Constitution, maybe that's a net positive. I don't know. I don't agree with all of their policy positions at a personal level, obviously. Thank you for the question, though. Yeah.
Wondering, since you have this broad view of FOIA, if you had a chance to amend the law and improve it, what items would you be looking at? I know, this is a little ancient history. When we were in the trenches doing journalism, we were reluctant to get into FOIA because it seemed like it would take forever to get an answer back. And, we're a news organization, we do it day to day. It just seemed like very cumbersome process in the old days. So I don't know if that's changed or not.
Yeah, I think that the delays that you're alluding to haven't changed a whole bunch. The 20 business day deadline within which the agency has to respond is just summarily ignored. And that's especially difficult for members of the news media who are so often under the pressure of a deadline. The fastest turnaround I ever got was I got my records within 48 hours. And that's because I submitted my FOIA request to a teeny tiny subcomponent of the Interior Department called the Board of Geographic Names. And the mental image I have in my head was these folks probably never get FOIA requests, so they were really excited to get mine. And they jumped on the opportunity to process it. But I think that's where getting creative about all the different places you could submit your request to is really important. I always propose that folks do multi-jurisdictional, multi-tiered requests. Maybe the FBI is an appropriate records custodian, but maybe they partnered up with the Ohio Bureau of Investigation or the Ohio Department of Justice. You're probably way more likely to get your records in a more timely fashion if you submit an Ohio Open Records Act request. So cover all your bases. But to your question of what I might do if I were in charge and I could amend FOIA, I think about this ad nauseum. I think that first I would get more FOIA officers hired, because while I said earlier, this is a federal law and I fully expect it to be complied with, especially when it's a journalist doing work squarely in the public interest, not a deadline. I also, at a personal level, do have compassion for the fact that a lot of people see FOIA as an unfunded mandate, right? This is a statutory requirement, and a lot of FOIA offices are understaffed. And we saw this really exacerbated during COVID when the backlogs just became exorbitant because folks didn't always have access to the classified servers that you had to be on site to access. There was no ability to remotely pull the documents. So I do have, compassion for that. But I think that I would infuse a public interest balancing into all aspects of the FOIA, because right now, Exemption 6, which has to do with personal privacy, the agency and the courts are by law required to do a balancing test. Does the public interest in this information outweigh any privacy interest that might exist? I would have that public interest balancing occur for each of FOIA's exemptions. You're claiming this is proprietary, it's a trade secret, but is the public interest in knowing how the algorithm is designed, stronger than that privacy interest? you claim this is deliberative and pre-decisional, but what about the public interest in understanding how the government arrived at this particular policy position? So I think that's the biggest change I would implement. Great question.
Following up on the long game ideological battle that you're looking at in the court responsibility. New York Times versus Sullivan, there are at least two justices who are clearly chomping at the bit to overturn New York Times versus Sullivan. In that particular, do you see a danger to New York Times versus Sullivan in our lifetimes? Well, my lifetime. New York is that.
In me, you know that there's a meme inside of me, there are two wolves. I don't know if you've seen this meme. Inside of me, there is an idealist and there is a pragmatist. And it's usually the idealist who wins out. I'd like to think no. That has been settled law for so long, right? Having to demonstrate actual malice as a member of a news media in a defamation claim. I mean, the standards should be high, right? The press is doing such important work. I mean, they really are the fourth estate, and there should be a really high burden for a defamation plaintiff to overcome in order to take down a member of a news media as a defendant. So I would like to say that it is settled law and that precedent is going to be honored. But yeah, it's unfortunate to see the Supreme Court is, it's not once what I thought was. I remember when I was in law school and learning about how Justice Roberts, he overcame partisan lines to protect the Affordable Care Act. And I remember thinking, like, they really are above politics. Sometimes I call that into question, but at the end of the day, I am an idealist, and I still do believe that the judiciary, for all of its pitfalls, is the strongest branch of government.
Have there ever been any constitutional challenges to FOIA?
To FOIA? I mean, obviously there have been FOIA cases that have made it to the Supreme Court, and some of the outcomes of those cases have strengthened the ability of the press and the public to get records, and some of those cases have strengthened the ability of the government to withhold records. But there's never been a constitutional challenge to the FOIA.
Well, the cynic in me that this profession tends to produce things just wait. I'm sorry, it just feels like what he mentioned, the coverage and all that. I'm just wondering. I don't know how that would stand up, but I think, of course, we can't predict anything.
We have to keep the faith, y'all.
What happens to your passion as an attorney and as a continuing student of the law when you see a decision like that had come from this past summer from the Ohio Supreme Court said that we should reasonably expect bones in our boneless chicken wings, and it's our fault if we choke on a bone? I don't know if you're familiar with that.
I'm not. I think I need a bit more context.
We'll talk.
Okay. So is the question how does dealing with the nitty-gritty of this profession affect my passion? Like, do I get jaded? Is that the question?
Yeah, I mean, because there have to be times when you want to open up a bottle of Jack, or there are other times when it strengthens your resolve. So those are the two extremes. And, so how do you, every day can't be easy, and every day can't be hard.
That's a great question. There is a lot of gray area. Sometimes I get really frustrated when, to me, there is a very clear-cut interpretation of the FOIA. These records are subject to disclosure. There is no interest in withholding them and keeping them from the press and the public. There are the occasional situations where I think there is a good faith question of law. Is this exempt or is it disclosable? And in those cases, I feel like my intellectual faculties are really engaged, and it's fun and it's interesting. Even if we end up losing, it's a good faith question of interpretation. But in those situations where I feel like the government is just being obstinate, or the culture of secrecy that has germinated within the agency is really taking hold, those are really frustrating situations. But I think what keeps me grounded and motivated is just having the best clients, because when I see the passion of the investigative journalists that I get to call my clients, it really just makes it all worth it. But also on a personal note, I'm a big proponent of mindfulness meditation. So what keeps me from grabbing the bottle of Jack is just taking a few moments to get back in touch with my truest intentions and remembering why I got into this in the first place. So yeah, it's difficult at times, but having the best clients makes it worth it.
Maybe it's a little bit of a cynicism in me, but when you requesting FOIA information from an entity that's being less than cooperative or has deep pockets and can afford to engage in the art of delay, and put it off and put it off and put it off, even if you follow through on the first line of recourse, which is presumably to sue them, and they keep delaying it, delaying it. What recourse does the requester have to ensure that they won't keep delaying into infinity and just eventually giving up and having it all go away?
Yeah.
So I think that there's a lot you can do before you get into court. So in about a third of the states, plus of course with federal FOIA, you have the ability to administratively appeal, and doing that can only help you. It can't hurt you. So that's a situation where you're asking the agency, hey, take another pass at the propriety of the withholding, or if you're in a jurisdiction like New York, for example, or federal land where a delay constitutes a constructive denial, you can administratively appeal that, and it's a good way of kind of pinging the agency into compliance. In about another third of the states, there's the ability to appeal to not the agency itself, but maybe an ombuds office or an attorney general to kind of get their eyes on it. And then in the third of the states, like California, where I grew up, there's no kind of administrative level recourse. But again, in those situations, there's nothing stopping you from hopping on the phone and using your powers of persuasion as journalists to kind of tell the agency, I'm doing work squarely in the public interest, can you work with me here? But if all of those fail, sometimes I encourage folks to get creative with what I call a FOIA process story. We saw this a lot during COVID, where journalists were trying to get numbers, transmission numbers in local communities, and agencies were saying, oh, HIPAA, we can't give you the data. Well, there are certain requirements that need to be met in order for you to invoke HIPAA. Are you a covered entity? You know, does the information implicate any personally identifiable information? Most of what these journalists wanted were de-identified data. There's nothing stopping any agency, even if it's a covered entity, from disclosing that. So they would write stories saying, this agency is not giving me what I want. And sometimes that naming and shaming was really helpful. So I encourage that as well. But then, of course, when you get into court, the added benefit is you have judicial oversight over the process. So if you can afford to go to court, do it. And if you can't, call the Reporters Committee, because we'll help you pro bono.